Your roll calling. Go right for it.
Okay. Jacob Beach,
Present in Kalamazoo.
Janine Brown, Gabriela Dela Cruz,
Present in Kalamazoo.
Jessica Glenn,
Present in the city of Kalamazoo.
Dr. Angela Grant Williams,
Present Kalamazoo County.
Marissa Harrington,
Present in the city of Kalamazoo.
Deshaun Houston.
Present in Kalamazoo. Thank you.
And I would like to welcome you all to the March 3rd, 21 Civil Rights Board meeting. Just a reminder that for public comment, please call 269-226-6573, 269-226-6573, and leave a voicemail message limited to 3 minutes. During citizen comments, your voicemail message will be played back for the good of the order. Closed caption is available via the City of Kalamazoo Facebook live stream and will also be available on the YouTube replay. Thank you. Director Chair, back to you.
Thank you. All right, we're going to move on to adopt the minutes. Are there any changes to the minutes? All right, motion to accept the minutes.
So moved.
All right, minutes accepted. I'm sorry, agenda accepted, excuse me. Approval of minutes. Are there any changes to the minutes? All right. Motion to accept the minutes.
Motioned.
All right. And
Second.
minutes. All right, minutes accepted. All right, any public announcements?
I have none.
None? All right. Old business.
Mr. Chair, once you made the motion to accept the minutes, you should take at least a voice vote, or some type of indication that the minutes have been accepted.
Okay. Maybe I missed it and didn't hear. All right. A motion to accept the minutes.
Right, I think that's what Commissioner Beach and Commissioner Harrington seconded. All you need now is a vote on that motion.
I'm sorry, vote on that motion. I apologize. Oh, I can't call it.
Oh, you can. You can say all in favor, please say yes or raise your hand, and all opposed, say no or raise your hand. It's that simple.
All right. Thank you. All in favor?
Aye.
Yeah.
Thank you. All right, minutes accepted. And you said no public announcements. All righty. Old business. We talked about creating, and I wasn't here. But thank you. First of all, thank you, Vice Chair Dela Cruz, for what you did. Thank you so much for filling in. So I really appreciate that. Thank you. Old business, create a committee to convene community input from Civil Rights Group.
What's the question on the table?
No, there wasn't a question. That was the old business. I'm just calling it roll call.
Sorry. This is Director Dela Cruz. Last time towards the end of the meeting, we talked about creating a subcommittee to organize the panel that we're planning to have at towards the end of the summer, where experts, I guess you could say, from the community will come in and give examples of different kinds of discrimination, so that there's a little bit more context to the ordinance, not just the words there themselves, so people will have some idea of what it looks like. So does anyone want to volunteer for that? I don't know how many people would.
So how will you do that? Will that be by a report of some sort, or you'll just give us feedback? What are you thinking?
I think oh, sorry, go ahead.
Sorry, this is Director Beach. I couldn't, and I might be remembering wrong. I wasn't sure if we were going to put that on hold until we got through the ordinances. We had talked about maybe putting that on hold for a second, so I wasn't sure if that had changed, or maybe I misunderstood.
I think maybe when we talked about it, I might have misunderstood and thought that we were putting the panel on hold until we got through this ordinance stuff. But I thought that we would organize the subcommittee just so we can start like gathering people up like outside of our meetings. And I think we said it would be 3 people, but I don't remember.
That makes complete sense. I just wanted to thank you for clarifying, Vice Chair Cruz. Taylor Cruz.
And I have a point of clarification then. If it was a committee of 3 people, would we be subject to the Open Meetings Act?
No, this body, the subcommittee, while it could be subject to Open Meetings Act, you're not making policy decisions. You're just doing some planning things. And so you're not making decisions that the whole body would normally have to make. And you're going to bring back a recommendation to this body. Therefore, you can meet and not be subject to the Open Meetings Act.
And would any record then produced be subject to FOIA or the Freedom of Information Act or anything? Okay.
Yeah. Any documents that you use in the course of your discussion would be subject to disclosure under the Freedom of Information Act, even though as a group you would not be subject to the Open Meetings Act.
I will. I would volunteer for that subcommittee if needed.
So Director Beach, Vice Chair De La Cruz, and Director Glenn.
Mm-hmm.
Okay. Any other comments regarding the subcommittee? I know we're going to focus in on going through the ordinances, but any more comments or anything? All right. Attorney Robinson Klein. Sorry, last name.
Okay.
I don't need to vote on that at all, right?
You may want to memorialize the fact of who you're appointing to the subcommittee. That's probably a good idea.
Should we wait? Well, in my choice, I think we should wait till after we get through this and then revisit that at that time. Just to move through this. All right. New business, review the Ordinance 18, Articles 3 and 5. So I asked Vice Chair De La Cruz to continue through this, and I'm sorry, 6, to continue through reading this. So Vice Chair, would you like to go forward?
Sure. I'll share my screen. Oh, sorry.
No, I was sharing screen.
And I'm gonna make you guys all really small. So if anyone has a question, just shout it out because I won't see it. All right. Okay, I think you can all see it. Okay, this is Chapter 18, Article 3, titled Enforcement. It says A, or 18.9, Complaint Process, Information and Investigation. A, any person claiming to have been discriminated against in violation of this chapter or Chapter 18A, fair housing. Wait, I have a question. Am I on the wrong thing?
No.
Okay, because I don't know. I feel like I might be skipping around.
Why is that? What ordinance do you have up?
It's 18. Is that the one listed?
Yes.
Okay, I don't know why I thought that. Sorry about that. Okay, I'll start.
You're in the right spot.
Okay, I'm going to start at that paragraph again. A, any person claiming to have been discriminated against in violation of this chapter or Chapter 18A, fair housing, must file a signed written complaint with the city manager or the designee of the city manager setting forth the details, including the names of the parties involved, contact information for the complainant, dates, witnesses, and other factual matters relevant to the claim within 91 days of the incident forming the basis of the complaint. Complaints not filed within or with the specified time frame will not be considered. So within 3 months of the complaints need to be filed or they won't be considered. And then B, the city manager or the designee of the city manager, with the assistance of the city attorney or designee of the city attorney, will review the complaint to determine its relevance to applicable city ordinances. Upon completion of the review, the complaint will be addressed through one of the following actions. 1. Referral of the complaint to an appropriate state, federal, or local authority for investigation. If referred to an external agency, the complainant will receive written notification of the referral by the city. 2. Conduct an investigation of the complaint with the assistance of the city attorney's office and personnel from any other city departments. 3. Dismiss the complaint if, after review with the city attorney's office, the allegations do not constitute a violation of city ordinances. C. In the course.
Excuse me, Vice Chair De La Cruz, I have a quick question if I could.
Sure.
Just for a point of clarity, the complaint process that is dialing, that's either through the website or dialing the city phone number, correct? And they collect at that point all of those things at that first, like the things described in point A, they collect all of that during that phone call? Or do they have to resubmit things after that?
As of now, we're collecting the ones we've gotten so far. Everything has been submitted because there's a place for attachments, and we've only got one through a phone call. The other ones have been through the website, the complaint process with attachments.
And then and then we also have I'm assuming we have a physical process. There's a physical process too.
I don't understand.
Or like by paper, there's a paper process as well, correct?
If they want to get a paper, they can print it out and do it by hand.
I'm just trying to think for accessibility of those that don't have access to a printer, or do we have them available to where they can come into? Is it available anywhere else, or do they have to print it out?
I think I'm trying to just think of all the things that we've said in our trainings that they can go. I think one person actually went to an agency to help them fill it out. So I hope I'm answering your question.
No.
It's kind of hard now. I mean, it's new and it happened during COVID, so I don't even know how all the ways we can do it in a COVID world.
Yeah, no, and I think that that's a really good point. So I would just hope that once the world opens up a little bit more and buildings start opening up, we have printed copies available that is someplace accessible for people to walk in and grab. That would be my just request. Thank you.
I would note that and see if there are some ways we can start doing that now in places that are still being trafficked frequently.
If I may, there is a rack in the lobby of City Hall, just outside the treasurer's office, where various forms for various departments are available. I would imagine that, again, once City Hall is generally open, there would be those forms. Short of that, if an individual doesn't have printing abilities, they can certainly contact 311 or Ms. Bonner directly and ask that we mail them a form. We can do that. That's not a problem.
Does anyone have any more comments about that?
Yeah, I have one, and I may have just forgotten this from being out for a meeting. Phone number they can contact and also do that over the phone with a representative at this present moment. Correct?
Yeah, they can call 311 and 311 will help them fill it out.
Gotcha. Not do it for them, but help them fill it out. Gotcha.
Or I mean, it just depends on what the need is, whether they need help or they need it done. It's evolving. That's all I can say. As we find out we have glitches, we will try to fill them.
This is Director Glenn. So I have a question, and I guess a point of clarification for 311, and I just want us to be intentional in our clarity about how to complete these forms. As an attorney who has really seen accessibility as frankly the primary barrier in people lodging complaints of all forms. And is there any guidance right now to 311 by way of memorandum from the city that employees who are answering those calls can complete the form on behalf of the caller? Because I'm still not entirely clear. And I think from an accessibility, like a disability accessibility standpoint, there's a big difference between someone at the call center or 311 directing somebody to the right form online and someone at 311 completing the form and hitting submit on their behalf. And I just want to make sure that's clear for all of us and for everyone listening, and that we can feed that back to the community. Thank you.
Mike, do you have an answer? Because I don't, maybe I should ask you, what do you mean by memorandum? Because I can't answer that.
Yeah, and so this is Director Glenn again. I mean more just a directive, right? Like, is there a specific directive from the city to 311 and how they should handle these complaints? Again, I think that there is a distinction between somebody completing the form on the behalf of a caller and submitting it, and them guiding a caller to the form, and the mechanics of that.
Director, this is Director.
I have a question. Go ahead, Director Beach.
And maybe I just want to make sure I'm understanding you. I think what we're really looking for is to making sure that if someone dials 311, someone is going to walk through the process from them and complete that form with them, and it's not just a simple referral. We want to make sure that 311 is not like an information referral line where they're just saying, oh, here's where the form is, can collect. We want to make sure that line is going to talk to the person and collect that information if that's necessary for that individual. Is that what you were asking, Director Glenn? I don't want to speak.
Right. I mean, if somebody doesn't have a computer, if someone has a disability and is unable to use that function, is, I guess, the point of clarification I'm looking for is that 311 employee is actually completing the form and submitting it for that caller.
Okay, I will get with 311 to make sure I understand how they're handling it and let you all know.
Thank you.
Thanks, Director Vana.
All right.
Vice Chair.
Okay, I'm going to start reading C. In the course of the investigation, the city manager or the designee of the city manager may request a person to produce books, papers, records, or other documents which may be relevant to the complaint being investigated. If said person does not comply with such request, the city attorney may issue subpoenas for the production of materials, and if necessary, apply to the Kalamazoo County Circuit Court for an order requiring. Is this, I guess I have a question about this. When they're requesting that a person produce these materials, does this apply to both the complainant and what is the word for the other person? The person they're complaining about?
I guess you'd call them the respondent.
Yeah, respondent.
It would apply to all parties involved.
Okay. Thank you. And then D, no person shall provide false information to any authorized city employee investigating a complaint initiated under this section. Violation of this section is a misdemeanor. E, action on the complaint will be completed within 91 days of receipt of the complaint, and the parties will be notified in writing if additional time is necessary. F, after the completion of an investigation, the city manager shall give written notice of the results of the investigation to the Civil Rights Board, the person who filed the complaint, and the person accused of the violation. If the investigation establishes that a violation of city ordinances occurred, the city manager or his or her designee may attempt to resolve the matter by a voluntary settlement agreement between the involved parties without legal action. 18-10 voluntary settlement agreements. A. Cases may be resolved by a voluntary settlement, agreed to by both parties, or by an administrative closure, if the request for settlement is withdrawn or a complaint is filed in court or with another administrative agency based on the same incident of discrimination. B. If the investigation establishes probable cause of discrimination, an offer to settle the matter will take place as soon as possible. The city may enter into enforceable agreements with a respondent to terminate the discriminatory conduct and reverse the effects of past discrimination. C. The respondent will be asked to 1. Cease and desist from the specific discriminatory act or practice involved in the complaint, and 2. Implement whatever actions and policies are necessary to remedy the discrimination uncovered in the investigation. D. Violations of voluntary settlement agreements are violations of this chapter, subjecting the respondent to prosecution and equitable action to enforce the agreement. 18-11 Injunctions. The city attorney may commence a civil action to obtain injunctive relief to prevent discrimination prohibited by this chapter, to reverse the effects of such discrimination, or to enforce a voluntary settlement agreement. What is an injunction?
It's an order prohibiting somebody from engaging in conduct. It basically says that you stop doing what you're doing. There's an order to that effect, and usually that you can get a temporary restraining order or a preliminary injunction. Then there's a show cause order in front of the judge as to why that order shouldn't be made permanent.
Okay, thank you. 18-12 Prosecution. A. Prosecution for a violation of this chapter may be initiated by complaint of the affected person on the basis of a violation of a voluntary settlement agreement, or at the direction of the Civil Rights Board on the basis of an investigation undertaken by the city manager. B. Violation of this chapter shall be prosecuted by the city attorney as a municipal civil infraction pursuant to the provisions of the revised, I can't pronounce that, Judicature Act of 1961, MCLA, the symbol 600.101 at SEQ. 18-3 Penalties. A violation of any provision of this chapter is a municipal civil infraction punishable by a fine of not more than $2,000 plus all costs of the action. The court may issue and enforce any judgment, writ, or order necessary to enforce this chapter. This may include reinstatement, payment of lost wages, hiring and promotion, sale, exchange, lease, or sublease of real property, admission to a place of public accommodation, and other relief deemed appropriate. B. Each day upon which a violation occurs shall constitute a separate and new violation. A violation proved to exist on a particular day shall be presumed to exist on each subsequent day unless it is proved that the violation no longer exists. D. Nothing contained in this chapter shall be construed to limit in any way the remedies, legal or equitable, which are available to the city or any person for the prevention or correction of discrimination. And then Article 4, this one's about us, the Civil Rights Board. 18-14, Civil Rights Board creation, composition. A, to implement the general policy and purposes set forth in this chapter, the City Commission establishes a Civil Rights Board. B, the Civil Rights Board consists of 7 voting members appointed by the mayor and approved by the City Commission, and 2 ex officio members who shall have no vote, but who may otherwise fully participate in any meeting of the board. C, members appointed to the board shall be residents of the city, reflecting and representing the diversity of the Kalamazoo community, and be able to demonstrate experience in civil rights, public accommodation, employment, disability, or housing law. Members to the board may be appointed who are not city residents, not to exceed 2 members, when there is a valid reason for such appointment, such as the member works in the city or has special expertise to carry out the duties and responsibilities of the board. 18-15, appointment and terms of board members, filling of vacancies, termination of appointments. A, except for the initial appointments, members of the board are appointed for a term of 3 years. The initial appointments to the board will consist of 3 members appointed for a 3-year term, 2 members appointed for a 2-year term, and 2 members appointed for a 1-year term. Members of the board may serve up to 2 consecutive terms. Vacancies may be filled by the same appointment procedure for the remainder of an unexpired term. B, the ex officio board members shall be appointed by the mayor and approved by the city commission. 1 member shall be a city commissioner, and the other member shall be a city officer or employee recommended by the city manager, but who shall not be a city commissioner or the city manager. 18-16, election of board officers. The board shall elect a chairperson for a term of 1 year, with no limit on the number of terms a member may serve as chairperson, to conduct its meetings, and as it may desire, elect a vice chairperson to act in the absence of the chairperson from its members. Rules for the conduct of board meetings shall be stated in the bylaws, as determined by the board and approved by the city commission. 18-17, secretary to board, administrative support. The city manager shall designate someone other than himself or herself to serve as a secretary to the board and shall provide such administrative support as may be required. 18-18, board subject to state law. Meetings of the board shall be conducted in compliance with the Michigan Open Meetings Act, MCLA 15.261, ET-SEQ, and its records shall be available to the public under the Michigan Freedom of Information Act, MCLA 15.231, ET-SEQ. 18-19, duties and responsibilities of the board. The board shall exercise its authority, functions, powers, and duties in accordance with all ordinances, rules, regulations, orders, and the city chapter of the city of Kalamazoo. The authority, duties, and responsibilities of the board shall include the following. A, foster mutual understanding and respect among the people in the city, and discourage and prevent unlawful discriminatory practices toward the protected classes described in this chapter. B, review claims of discrimination brought by residents of the city of Kalamazoo and make recommendations for resolution following investigation of the claim by the city manager or the designee of the city manager. C, review and analyze of conditions, practices, attitudes, policies, and other factors within Kalamazoo that contribute to discriminatory impact and further inequities, as well as evaluating the impact of anti-discrimination efforts. D, make recommendations to the city commission and city manager on ways to improve city programs and ordinances to eliminate discrimination or remove effects of past discrimination. Sorry, I'm having trouble breathing through my nose, which is why I sound like this. E, engage.
Sorry, I need me to step in for you. So
it's okay. I'm
okay.
Handling it. It's just I feel
You're
like I'm
great.
Okay.
You're doing.
E, engage in public awareness building activities to ensure residents are informed of increased local protections and the role of the board, including issuing an annual report of the activity of the board. F, engage with federal, state, and local agencies to assist in addressing issues of discrimination in the city. Does that so that would be like government agencies and nonprofits, or just, is that like, what's an example of that?
I think you covered it.
Okay.
We've already kind of done that with our fair housing programs, where we've partnered with both the Michigan Department of Civil Rights and the Fair Housing Center locally.
Okay.
So that's a good example of what that phrase means.
Okay, thank you. G, the board shall provide an annual report to the city commission regarding complaints received and actions taken. H, establish bylaws and procedural rules for its meetings subject to approval by the city commission. And that's the end of this week or this month's sections. Does anyone have any comments or questions?
So I just a point of clarity. Our annual report would that be in January typically, or when should that be released to the public typically, or do we determine that?
If I'm not mistaken, I think it's February, but I could be wrong. I had to go back to the original. I have it right here. I'll look through it, but I have the. Where is it? Hold on. The bylaws. Let me check the bylaws really quickly. It may be in the bylaws. I don't see a time, Director Beach, or a month rather.
So Attorney Robinson, is that just something we determine and it has to happen annually?
No. I would say it should be issued contemporaneous with your annual meeting. And since you really started at the end of 2020, I would expect your first report would be issued shortly after the first year in 2022. So it would basically be the last few months where you didn't really do much in 2020. 2021, you've been I assume you'll be active, and you'll have something to report back to the City Commission at that time.
Thank you for that clarification.
Yeah, I would say you should issue your report. It should be approved at the annual meeting in February. So that would give you the end of the year through January to put together a report. It doesn't have to be anything particularly lengthy, but then once it's approved, then it can be issued to the city as a whole and to the City Commission as a report from this board.
Attorney Robinson, do you have just and I'm sure I can get this publicly, a step-by-step guide of what that needs to look like?
I don't, but I'm sure we can find a model that other boards in the city have used.
Cool. Okay, perfect. Thank you. All right, you are ready to move on to the fair housing training feedback discussions. Is there a slide for this, or are we just opening this up? Are we going back through talking about this, what this is? Is there slides, or are we just opening this up for discussion?
I personally wanted to discuss with the board some of the observations / feedback from the fair housing trainings. I think it's important for us to be aware of any questions that are coming up in those trainings that specifically are being directed at us, towards us, so that we either know how to handle it or we're just aware that the questions are there. So something specifically that caught my eye or my ear from the last training was it just seemed like, especially from property owners / landlords, it seemed like there was just a huge misunderstanding, misconceptions, miscommunications about what this ordinance actually is. And I know that in the very beginning of us all coming onto the board, that there was some talk about community trainings, like us being involved in community trainings, or some sort of like very similar to these fair housing trainings where you're opening it up, but it would be us maybe talking through the ordinances or asking questions or whatever. And obviously with, Director Bonner and Attorney Robinson, hopefully. But I just think that there is a very strong need for us as a board to directly interact with / address questions and concerns. Because there were just a lot of things that I was hearing where, first of all, I don't think people are reading, or they are reading and aren't understanding, or you know what I mean? I think there needs to be some clarity, because in order for this to be our goal for the ordinances and for this board is not to create a divide in the community, and is not to disenfranchise, right? That's not the goal, right? So I'm wondering, is there something a little bit more proactive as a board that we can do in the vein of, small group sessions or Q&A, or I don't know, to alleviate a lot of the concerns that I was hearing from the trainings. And they were directed at us in the ordinance, not general fair housing things. It was specifically us. So that's what I wanted to discuss tonight.
This is Director Beach, and I think Director Bonner and I are working on some trainings around vouchers and things like that, which have been asked by the community. But I think the idea of almost a meet the Civil Rights Board forums, where whether it be one or two of us and really targeted to all parts of our community, and also landlords, and having people to ask questions about the ordinances and have it get directed from us. I think that would do a lot for education around the community, trust building, and buy-in. I think buy-in to this process that is not just we don't want another bureaucracy. I can't say that word today, guys. I'm sorry. Bureaucratic process. We don't want another. And so I think that is something that this board should consider doing.
Hi, this is Director Brown, and I want to resonate with what Director Harrington and Director Beach was saying. I totally agree with it. I attended the fair housing training, and for me, I agree with having, building the relationship and building trust, and having them ask us questions directly and being able to answer those questions. I think before we do that, though, let's just make sure as a board that we're fully aligned, because I think we still have a lot of questions and understanding. I don't want to misspeak, and I don't want to share information that's not correct. The other thing that I'm wondering about is that, I love what you're saying, Director Harrington, as far as like things that are directed towards us, but I also had a very strong concern that people just didn't understand what was discriminatory and what was not. There was, it seemed to be a whole lot of confusion on any of that. And so I'm wondering, and maybe this is outside of our jurisdiction or what we would be responsible for, but maybe it's somehow, I don't know who we need to talk to possibly recommend maybe some, kind of short list or some, because again, people are not going to read, and some people don't read well anyway. So you also have a lot of visual adults. So I'm just wondering, if they're, besides the fair trade, the training, that maybe there can be some job aids or just some guides or something that are just very quick, very easy, very visual, where they can, this is what this is discrimination, this is not, and having those examples out there in such that, say that someone is looking for a tenant, these are the types of things you want to avoid, and these are this is what you should say. I just wonder if there should be some, and again, that might be outside of what we do, but I'm just really concerned because I almost feel that because there was so much confusion on what was discriminatory and what was not, I'm concerned that people will be discriminating not knowing, and then now they're before us, or people are bringing up issues with them, and it's not very clear. So and to me, it almost feels like that's just another problem in and of itself. So I don't know. I'm just wondering if that's something we could recommend to someone, maybe to those doing the training? You know, they might want to give some guides or just something, because they were asking questions that I was just like.
That feels, because I hear that's the feedback I hear from landlords all the time, is they don't want to ask, they don't know what questions are not allowed to ask. And I think just some simple education. And I think, is that something that we could ask the city to invest in some public materials that are simple and easy to understand around these ordinances and around, because it sounds, again, I don't think there are people who just need education. Oh, Vice Mayor
Griffin.
Hi, yes, this is Vice Mayor Griffin here, and I just wanted to offer just a little context and just weigh in. And of course, I have no say so. I want to reiterate that, and ultimately what you decide. I love the fact that there's so much discussion on both sides to educate both landlords and our residents about their rights, because you're right, there are a lot of people who are not clear. One thing that I want to make sure I lift up is when it comes to the slope of what you can and can't do, the Michigan Department of Civil Rights gives pretty clear guidance on that. And I would want to make sure that we don't try to step outside of that, because one of the things that, you know, you will ultimately realize is that there's a very fine line between people wanting to be clear on discrimination and people who don't want to do the right thing and trying to go through a whole lot of stuff to figure out their way around it. And there is a clear difference between the two, and just wanting to make sure I lift that up in this process. But thank you all, and this is a great conversation.
Thank you, Vice Mayor. Oh, sorry.
No, I just have a clarification. I'm following the conversation. I just want to make sure, because there are two sets of things. There's training and accountability for landlords, and training and understanding for residents. And so the training we had was just landlords, not residents. So, and then there's also the two sets of issues. There's the state and federal, and then there are the locals. So I'm just trying to figure out what it is that we're talking about, or are we talking about it all? Because I'm trying to figure out, like,
well, Director, Director Bonner, this is Director Brown. Part of it is all of it. I'm not trying to mess with the federal stuff. So I agree with you, Vice Mayor. I'm not trying to, I don't think we should, but it's definitely for our stuff, for sure. I just, even reading through the ordinance with all of you, and I want to say, Director Dela Cruz, I'm so happy that you keep asking questions. What is an injunction? Trust me, I'm sure that people read the ordinance and have no clue what they read. So I'm just wondering, you know, at least from what we're responsible for, that's the way to put it. If there's just some things, some aids or something that we can put out that could help people to navigate that a little easier, so that there's not a whole lot of confusion. And I think it has to be done for both landlords and residents. Know your rights. I know that we like to post up, you know, long things of know your rights, but I just think it needs to be short, simple, sweet, to the point, where it's easy, it's accessible, it's something that they can grab, and it needs to be done for both landlords and residents. Because like I said, I was on the training and I felt like the trainers were doing a lot of explanation that, you know, as some of you, you know, mentioned, is already out there, but for some reason they're not getting it. And I get it, you know, sometimes people play dumb, but in some cases, at least in my case, the one I attended, these people were really confused. So I'm just concerned that, you know, as we're trying to service people in that way and ensure that there's no discrimination, I'm thinking in building trust that the more we educate you, the more we educate yourself, maybe you'll never come before us because you'll understand it. I just feel like there's going to be a lot of things happening that people are just not aware of. I get that sometimes people don't want to do right. There is a category for that, but there is a category of people really just trying to run their business and do what's right, and they can't because it's really not that easy to understand. I have a master's degree. I'm in science of all that, okay? And I am stuck on the ordinance myself. So again, I appreciate us doing this, but I'm just wondering if just a little bit more can be done to just make sure that, and then once it's out there, it's out there. I mean, you do have a responsibility to read and do what you need to do. But I guess that's what I was just saying, along with that, just something.
Can I ask this question real quick? So are you talking about just like upfront education or through the consultation process, right? So if someone files a complaint, are we talking about at the end of it? Will they understand through consultation where they're going, or you're just saying, hey, I don't really know what this means. I'm not sure if I'll fall in this category, but I really need to know if I'll fall in this category. Is that what you're talking about? Understanding what category they may fall in based on discrimination? I'm sorry.
Yeah, that and not only that, just understanding it anyway. So I'm just wondering if we can somehow, it's a lot to swallow. I feel like we're boiling the ocean a little bit, and even us, we're taking it in chunks, and I'm taking notes as I'm listening to, Director Dela Cruz, because she asked questions. I'm writing down those questions and those answers going, so I'm getting these aha moments. But again, I know that people have gotten that ordinance, and education and knowledge is at different levels. And I'm just wondering, if we could have something maybe a little bit more condensed, maybe small chunks of stuff, maybe, some visuals or something, just so that we ensure that, I'm thinking that if we can help to avoid people having to go through this entire process, that'd be great. But even if they do, they need to understand what it is and why it is and what's happening. I just feel like more education on both our ends and the ends of the people that we serve is absolutely important. And without that, we run the risk of having more problems than not. Mm-hmm.
Yeah. Director Harrington, sorry, I cut you off.
Oh, no, it's okay. I just wanted to clarify what I'm requesting and referencing. In the very beginning, we were told that a part of our job was going to be education and advocacy to the community about this ordinance. But since that conversation, there has never, and from my remembrance, correct me if I'm wrong, but a practical action plan of how to do that has not been discussed. So I would like to bring that up now. Very specifically, can we discuss, or is this another committee? I don't know. Is this the same committee from before, and maybe I just need to join it? That we come up with a very specific, maybe call it a community engagement plan or a community education plan or something, because that will have to include marketing and social media graphics and I don't know, it might be door knocking, but I really think we need to sit down either as a board or as a committee and really flesh out, what does community education about this ordinance look like? Mm-hmm. Action.
I think that aligns really directly with what the subcommittee we just talked about at the beginning of this meeting is about education. Yes, it was for us and but that really aligns. And I just can't agree with the actionable steps that really talk about what does education and what does advocacy, like, what does that look like? And to me, those committees seem very, very similar. I don't want to make more groups. So maybe we expand the scope of that, but I would recommend that we expand the scope of that. And I want to lift up that, like, yes.
And if we do, then this Director Harrington, I would be interested in joining the committee then.
Well, then that would be 4. I think it's a quorum. That's over half. It's only 7 of you. Am I right? I'm right? So now you have 4 people in the community. I'm just trying to keep y'all from an open meeting.
I'm happy to step down from that subcommittee. So it can be Director Harrington, Director Glenn, and Director Beach.
I'm also happy to sit out. I actually think, and this is Director Glenn, I actually think Director Harrington's background in real estate is really critical to that conversation. And so I'm happy to sit out and then recommend some names of folks that I think would be good for those presentations.
Who's interested? Because I can't, oh, go ahead, because I can appoint if you're ready to move on those pieces.
Can I say one more thing though, as
Sure.
to the conversation about education? And I think that there are two pieces worthy of lifting this up. And I think Director Brown's comments about just confusion about who the board is and their purpose and the purview are very well taken. However, if we could, if discrimination and ending discrimination were as simple as saying, we just need people to know what they're doing isn't okay, right? There would be no purpose for this board. And I do think that it is just a straw man argument in many of the issues that have been raised. And it doesn't behoove us to spend a whole lot of time, paying attention to some of those comments. But I do think that two areas that I see is really vital, in addition to just the purpose of this board and really why we're here. But education about process and filing the complaint and having those graphics, not just words, would be very, very helpful in terms of accessibility. The other is ways that this ordinance has expanded on state and federal law, right? So we already have all of those protected classes and bases of which people can really avail themselves of some remedy. But we have decided as a community that there are additional people that are worthy of protection, right? And so in my perspective, having that know your rights information about and here is what we have done through this ordinance and the creation of this body that expands on that would be very, very helpful. And then lastly, I had a question, because I know that there had been some landlords who had participated in providing feedback when the ordinance was drafted. And I wonder if there are some landlords out there that would be willing to, if we're going to engage in a public education campaign, would be willing to address their colleagues. Because I think we can talk about who the Civil Rights Board is, but I do think a colleague in that industry speaking to some of those concerns with a greater level of specificity, but also understanding who's just asking the question to, I don't know, throw a wrench in it, the process or to give folks a hard time, they will be much better situated to know who those folks are and who has a legitimate question, if you will.
Director Bauer.
I just want to add that I do believe, I got a lot of invitations from the Fair Housing Center today, but I do believe that they have started, they have scheduled trainings for tenants, for residents. And so what I would recommend, I will get you those dates and links as soon as I get them, that you all attend that so you'll know what the residents will need. You'll be able to hear their questions. We've only heard the landlords. I don't know how many of you, if any of you went to any of those landlord trainings. The first one we had was just staff and it's you all. Just so you know that they are getting ready to start that. So we don't want to recreate the wheel. And those trainings include both both the federal and local, but it would be a good way for the subcommittee to find out what we need to do, what's missing, why what's not being heard right, how do we need to format it differently. And I do believe, but I just got invites and not a prep email, so I will figure it out tomorrow so I can send you all the dates, and it'll be on our website like the landlord training was. So you could put the word out. That'd be a good thing that you all can help do, is make sure the word goes out as broad as possibly for residents that this training is coming up. Because it would, like I said, a lot of folks don't know, they don't know the local, but they also don't know the state and federal. So just keep that in mind.
Thank you.
And can I say just one last thing? This is Director Glenn, and this keeps running through my head. I don't think it's a bad thing for landlords or employers or anyone else to take a beat. And if this and think, wait, and what I'm doing is that discrimination, right? Is that discriminatory? And if that is part of the effect of an impact of creating this ordinance, I'm already think that is a really valuable exercise. Just throwing that out there.
So going back to what Director Harrington was talking about, and as far as being a part of that committee, because you mentioned it, Director Houston. So again, just offering my skill set again for stuff like this. I attended the trainings. I felt though, with the landlords, I think a lot of reason why there was questions, there was a lot of history covering about where discrimination came from. And there was a lot of, and I think that's great and all. But I almost felt that more needed to be spent on the connection. So but again, that's just me and my learning and development mind. So I would love to, assist, be, sub to whatever that committee to, when we do get those topics or whatever that is, be very willing to format that, make sure that it's something that is applicable, because what you're saying, Director Glenn, is so important. I don't want you to just come and just have butts and seats just for the fact of getting information, but giving the information in such a way that you do something with it, and that you go back and, maybe almost more of a workshop for landlords and residents to understand that process, possibly even some check-ins and follow-ups, so that it's something that truly resonates with the people that attend, and it does truly change behavior. We're asking people to change behavior. This is not just about education, this is behavior change. So it's gonna take a little bit more than just a slideshow and a history lesson. So, and not to knock it, it was really, really good training. There were some great things historically that I didn't even know, but at the end, listening to the questions, I was just really concerned that the residents really understood now what to do with it. We're asking for behavior change. Behavior change does not happen just because we gave information. So I would definitely like to help in doing that, because this is what I do, doing it for the last 15 years, holla at a girl. So just want to throw that out there.
Thank you. Director Bonner.
I also just want to share a very interesting kind of training opportunity that's showing up. And I'm going to say this publicly so people can know they can do this. People are sending me advertisements of landlords that break a lot of laws. And because it's not a formal complaint, they're not complaining. So what I'm doing is developing a letter that has all of our discrimination that I can check and say, these are the ones you're violating. If you're ever reported, you will be found guilty. Just, but I don't have, our complaint process based on a person that's harmed, not in general. But it has been very interesting that I'm getting all of these. I think I have about 12 of them now. And it's a learning process, because some of the people, they haven't changed I don't know if they just haven't changed their advertisements. I don't know. But our process is that our process of complaints is if a person is harmed, not if it's a bad email as of today. Not an email, but you know what I'm saying, a bad advertisement. So that is another way that we're training landlords, because a lot of, I think there are 2,000 landlords. We probably had 150, 200 come. So we didn't hit the group.
Thank you, Director Bonner. Vice Chair.
I just wanted to ask, hopefully, a quick question. I don't know why, but I'm having a hard time imagining these questions that kind of like fall out of the different categories, or like that are outside of the different categories, where like people, like where the people who attended the landlord trainings observed some like misunderstanding of the ordinance. Like, can you give us an example of one of these questions? You don't have to like say an exact example, but just kind of like a general, you can make up the different like words that they used. I just like, I'm having a hard time imagining like what kind of question somebody would ask where like it seems like they're misunderstanding rather than just wanting to continue to do the same things but like have it be legal, I guess.
Yes, that this is Director Harrington speaking. My suggestion is more so around making sure that we're doing our part, not necessarily answering all the questions, because the questions that I heard were troublesome. But there was some validity in, well, we need clarification, and hearing that in conjunction with what we were told in the beginning of part of our job was going to be, which was going to be education. I'm speaking to that. I'm not going to specifically speak to what was actually said, because I'm just going to leave that right there and leave my eyes here.
So the moral, Director Harrington, is that people didn't know what they didn't know. Chapter 18 at all, and that caused a lot of questions around that particular presentation. Is that what I'm gathering?
I would say that, and I think I will say there was a specific comment of the Civil Rights Board needs to clarify this. The Civil Rights Board needs to clarify that.
That's clear.
I'm more so those comments than excusing away, or by no means saying let's do this, cater to people who want to do what they want to do anyway. More so speaking to the Civil Rights Board needs to clarify, which I agree with. I agreed with that. I didn't agree with the presentation of the comment, but I agreed with that comment. Okay.
So, Attorney Robinson, do you mind helping me appoint a subcommittee and what that looks? Oh, yes, sir. Yes, Director.
I just want to recognize, I think Director Graham-Williams has her hand raised.
Oh, did I miss you?
Yeah, and I just wanted to, before we move on.
Oh, I'm sorry, Director Graham-Williams.
Thank you, Director Beach. I think my hand is blending in with my painting behind me. It is speaking to something that was said earlier. So, Chair Houston, please go ahead and finish your question to Director Robinson, because I want you to stay on track, because this is, of course, so important, the conversation. It would have been a left turn to something else. So I'm patient to wait until you're done with this piece, and then I can go back and ask my question. Thank you, Director Beach. I appreciate that.
Thank you, Director Beach. Yes, ma'am. I will not forget. Attorney Robinson, what is the process of appointing a subcommittee?
I think what you can do is ask for a motion to appoint a subcommittee consisting of Directors Beach, Dela Cruz, and Harrington to, I think, and we've kind of talked around it, as I understand it, it is to convene community input from, I think, both civil rights groups and maybe the community and landlords. That's what I kind of understood where that is going, in terms of, for the purpose of educating folks on, I should say, the community on the duties of the Civil Rights Board and the ordinances.
Okay, so I'd like to call.
I hope I've captured it.
All right, so I'd like to call a motion to create a subcommittee with Directors Beach, Harrington, and Brown, specifying a call to action. What does the Civil Rights Board do? Educating residents and landlords, including marketing material and whatever the resources that they need to help educate our members of Chapter 18A, or the citizens and landlords of Chapter 18A, so that they have a guide to be able to understand a condensed version of what this looks like. Did I capture that for you all? Miss anything?
So moved.
Just to clarify, this board consists of Director Beach, Harrington, and Brown. Is that right?
That's what I understand who wanted to volunteer. Am I right in that or wrong?
Mhm.
Okay. Unless anyone was interested, I know that Director Glenn said that she'd be happy to step down, and Director Graham Williams, any interest? Okay. All right. So I heard one motion, or yes.
Second, Director Brown. I second the motion that was made by Angela, not Director Graham Williams. Sorry.
All right, we accept that. And so is there anything formal that we need to do? It's going to be in the minutes, as I understand, Attorney Robinson.
If you want to, you can ask for discussion on the motion, although you've kind of hashed it out. And if there's no discussion, then you can move to a vote.
All right, perfect. Just want to make sure for the subcommittee. All right. All in favor, say aye.
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 All righty.
Director Brown.
It is created. So,
do we have to ask for opposition on these votes?
say that one more time.
We have to ask for opposition. So we didn't say if there's anyone opposed or anyone that wants to abstain. So on every vote, we have to make sure that we give space for people that either want to oppose what we're voting for or abstain.
I think I captured that when I said all in favor, aye. Maybe I didn't voice it correctly or say it correctly.
You did, but then don't forget to follow up with any opposed.
Oh, sorry, any opposed? Excuse me. Does not sound like it. I'm still getting used to this, guys. It's so different. You guys are kind. Now can I formally say that the subcommittee is created? Okay. So Director Graham Williams, I do not want to forget about you.
Thank you. And I'm patient to wait. It was such a robust conversation. I was following with great interest. I did not have an opportunity to make it to those meetings. And so I'm so glad that there were members of this board who were there to show up in our favor and represent us and bring back such valuable information. So I was riveted and excited and some points disappointed, but thank you for those of y'all who were able to go. I did want to ask Director Bonner about something that she said about you're getting those emails. And I think that's a wonderful thing that people are communicating with you and wanting to bring it to our attention. And I also want to validate your decision to send a communication as to that landlord who is allegedly breaking some of those ordinances. But what I was wondering also is there a way for you to communicate with the sender to remind them of the complaint process? I just don't want to miss that step as well.
I can, but most of the ones that sent me, they did not apply at those places. So nothing happened to them. They were not, what's the phrase, the legal phrase? They were not the wounded party. Some of them were not even really looking for themselves. They were just looking and found. It's been really interesting. The people who are supportive of this are supportive in a lot of ways, even to just look through real estate ads, so but I will add that in my return email that if you or somebody you know what you're saying, I can do that.
Thank you.
I'm not real articulate tonight, but this is a Director Bonner talking.
No, you're not. We understand exactly what you're saying. You're doing fine. Thank you. As are you, Chair Houston. Thank you for your leadership.
Chair Houston, this is Vice Mayor Griffin. I just would like to ask Attorney Robinson as a point of clarification on that piece about advertisements. Is an advertisement in and of itself a violation, or do you have to specifically apply in order for that to be a violation, just as a point of clarification?
You're right. And even if it is a violation, just have a advertisement that doesn't follow the fair housing law. Now, most of those advertisements, I'm assuming, because we really don't have much in our ordinance that addresses that, but I think what Ms. Bonner is talking about are some people who are making statements that under our training that we've received from the Michigan Department of Civil Rights are clearly violations. And I think rather than what we're trying to get is cooperation. We're not trying to do the gotcha game. And I think what Director Bonner is doing in terms of informing people, educating them what they're doing is not right, and asking them to change it, but also telling them that if they don't, then we're going, if we receive another complaint, we'll forward it on to the appropriate authorities.
All right, the next topic, everyone ready to move forward, is the Open Meetings Act overview. And if I could, I'll ask Attorney Robinson to conduct that.
Thank you, Chair Houston. I don't know really what you want as a board, because I could spend an hour going over the Open Meetings Act. It is a topic in and of itself that I have presented on in the past. Basically, for your purposes, there's very little. I'd rather kind of handle things as we address them, and I also want to separate the Open Meetings Act from Robert's Rules of Order. So they are a little different.
Attorney Robertson, this is Director Beach. I was the one who put that on the agenda. We had discussed it at one of our earlier meetings, and where I guess as a board member looking for clarification is around what meetings are like, how we can communicate. Are we like how we should be communicating with each other to make sure we're following Open Meetings Act? What constitutes us having to follow the Open Meetings Act? Those kind of clarifications we had talked, making sure that everyone had a understanding about how we needed to operate.
Okay. Well, first off, and I'll go over the definitions. It's probably the easiest way to do it. I can do this in probably 10 or 15 minutes. Number one, public bodies are subject to the Open Meetings Act. Take it from me, you are a public body because you have governmental authority to take action. So you are, and our ordinance makes you that. So even if you weren't, because the ordinance says you're subject to the Open Meetings Act, you're subject to the Open Meetings Act. So you are a public body because you do exercise local control. Now the question then becomes is when can you take that action? Well, you can only take that action in a meeting at which a quorum of you are in attendance. That's why we were a little careful about subquorums. You have to be careful about that, and I'll get to that in a moment. But a meeting is a where you have a quorum of the body together, and they are either deliberating toward or making decisions on public policy. So that's the definition right from the statute. So if you've got at least 4 of you together and you're talking about matters that are going to come before the board, you have to do that in an open meeting that's properly noticed, and the public has to be invited to be present. If you meet as a group and you're discussing stuff that's coming before the board and you haven't done any of that advertisement to the public, then you violated the act. And you also have to even be careful in terms of communicating with each other by email. If you, and we've gone over this a little bit in prior meetings, is if you start talking about, well, what do you think? And somebody hits reply all, you've now created a violation of the act, because again, you've got more than 4 people or more than 3 people, and everybody has heard what at least one member thinks about a particular issue. So the best way to do is don't have any discussions out, at least in regard to Civil Rights Board issues, unless you are in one of the properly noticed meetings. If you're having email conversations with other members, even if it's a subgroup, you run the risk of being accused of violating the Open Meetings Act. The other thing is that the courts are clear about is that you can actually have a constructive violation, because we've had the Open Meetings Act since the 1970s, and so we have 40 years, almost 50 years of experience of public bodies trying to get around the clear language of the act. And so every once in a while they get caught, and the courts kind of wag their finger at them and say, you shouldn't do that, because not only can what you've done be undone, you're, as individual members, if it's a willful violation of the law, that is a criminal offense. Now, while it's only a misdemeanor, it's nonetheless a criminal offense. And so there are some sanctions that if you're willfully violating the law, that can be triggered. And while it's not common, there have been public officials prosecuted for violating the Open Meetings Act. So that said, if you're in a meeting, if there's a quorum of you and you're deliberating toward a decision, or you're talking about or actually making a decision on a matter of public policy. Now, there are some exceptions. And of course, you have to be careful, because nobody wants the exceptions to swallow the rule. For instance, if you are engaged in a conference, let's say there was in the time of after we get through this COVID, there may be a conference on civil rights for training that a majority of you go to, and you're attending the conference and the like. You can do that, as long as, again, you're not deliberating. You're just there as a quorum, and you're getting information, you're getting training. So that's okay. The other thing is what they call a chance meeting. 4 of you happen to run into one another at a store, or perhaps at a party. And that's the other one, a social gathering. If it's a social gathering, and for instance, you may say, we've been working together as a group, and somebody says, I'm going to have a barbecue this weekend at my home. I'm inviting all of you. We're just going to have some burgers and brats and a couple of beers, and we'll just get to know each other a little bit better than we've been able to get as a board. As long as you're not discussing the work of the board and you're just socializing, not a problem. That is okay to do. So those are some exceptions. The other thing that people often ask about is closed sessions. But there are very few closed sessions that would be applicable to this particular board. They're listed in the statute, and for the most part, you wouldn't be going into closed session. The only one that really comes to my mind is if you wanted to consider an attorney-client privileged communication. You can go into closed session for that purpose. But short of that, most of the other closed session or exemptions to the Open Meetings Act are not applicable to this particular board. I think that kind of covers it. There are obviously other requirements about permitting public comment, about when we get out of the age of COVID, meeting in a public place, keeping adequate minutes, and if there is a misstep, what you do in terms of reenacting an action that was taken where you may have made a misstep. But to that end, I try, along with Director Bonner, to make sure that doesn't happen. Because if you're providing, I always look at it, and what I tell everybody is that as long as you're doing things in a public realm and you've adequately notified the public that you are meeting, then it's like a safe harbor, because as long as you're complying with that notice and you're opening yourself up to the public, what you do is going to be acceptable under the Open Meetings Act. Where you get into trouble is if you're taking action outside of what the public can observe, hence the concern about emails. And I'll leave you with this anecdote. happened in the city of Ann Arbor. And I also, they were there, and I think they have like a 9-member city council, and members of the city council were emailing one another during the course of the meeting on city computers that they were issued, and they were talking about some of the people who were coming before them on various topics. Someone got wind of that and asked the newspaper, made a request for those things, and there were some rather embarrassed city council members in Ann Arbor for, well, I don't think they were using derogatory language. They held some people in ridicule, and so that was embarrassing. And so that's one of the things that can happen. And so that's, you have to be careful. There also have been cases where usually it's where city council people are trying to get rid of like a city clerk or a city manager or a village manager. And again, they're meeting in somebody's home and cooking up how can we get rid of this employee, rather than going about it the right way. And so those are the kind of cases that make it to the courts. So I hope I've given you enough of an overview.
Yeah, no, that is very helpful. Thank you so much.
Thank you, Attorney Robinson. Any questions about that at all? Thank you so much for that. All right, we are going to move forward to citizens' comment. IT, are there any citizens' comments?
There are actually no comments at this time.
Okay. Any miscellaneous comments by the board?
Hi, this is Director Brown. Real quick, I was just wondering if it would be appropriate to speak out publicly. The letter that you received, Director Bonner, concerning the comment about representation of disabilities on the board. I'm just wondering if that would be appropriate to address, as it seems like there seems to be a lot of confusion concerning disability, because this is the one that you sent, and then I received a couple of comments afterward, or came across a couple of comments about disability representation, non-discrimination against disabilities. Can we just speak to that real quick, just openly, and just for clarification, because it just seems like this keeps coming up. It's very interesting.
Attorney Robinson.
Well, I'll say this. If you want to discuss it, you can. However, at this point, I would advise against it. There is currently an inquiry from, I think, a Channel 3 reporter, and I'd rather handle that as opposed to maybe exposing members of the board to the news media on this issue. It's a tricky issue given the complaint that's been leveled, and I'd rather not discuss that publicly at this point, given the fact that it is an ongoing matter.
Okay, thank you.
Any other comments, board comments? I have one. I know in the last meeting there was a talk about a tracking process, and a tracking process for making sure that we were kind of notified. Attorney Robinson, this is probably more specific to you, because I've got the update from the vice chair, and I don't want to make it a big deal. Is there a CRM of some sort, or some documentation system that you keep notes at, so we can read decisions that were made, or you came to a conclusion, or things like that from the investigations after they've come through the process when you're done with them? How do you keep track of it? Is it paper form? Is it through a CRM system of some sort that's electronic?
Well, we've not engaged in an investigation yet, but we would, and again, this is something that Director Bonner and I will be working on in terms of keeping you informed. My guess it'll be a paper type of form, or it'll be like a PDF that we might send out by email, but we will document it and provide you the members of the board with that information.
Okay. I just wanted to, from my own mind, I just wanted to see where we were.
It very well may be in summary form, as opposed to, every question that was asked and answered, but nonetheless, you'll receive a report of our investigation.
Okay. Are there any other comments from any of you all?
Director Glenn has a very adorable puppy. That is my comment. Director Glenn has a very adorable puppy.
Yeah, adorable, and the reason that I'm yawning through this meeting, because he's the reason I no longer sleep.
How old is he?
He'll be 9 weeks, so he's brand new.
I know that feeling.
That's a new baby.
Well, if there are no more comments, I would like to, as chair, adjourn the meeting, and hope that you all have a very good evening, and thank you so much for your time and this discussion today. You all take care.
Are you going to contact those on the subcommittee to discuss real quick? The committee we just put together, who's going to be sending out when we meet? When we talk, when we discuss? Somebody in charge of that?
Director Brown, you didn't even have that miscellaneous comment there. I didn't even think about it.
I'll start an email chain if that's what we need to get going.
Okay, sorry, I was trying to come off mute. My mute was stuck. I was like, wait, I gotta. Okay, I just wanted to make sure, because
the three of us again. Who is it?
It's you, myself, and Director Beach.
Okay.
No, Director Harrington Brown. Oh, okay. I thought that was.
Yeah, I was talking to Director Harrington. Yeah.
You're fine. I'm sorry.
No, you're fine. You're absolutely fine. I just want to make sure we get together. Okay, that's all I wanted to ask.
Okay. Good night, everybody.
Good night.
Good night.